You are now at the trial preparation stage for your case. What this means is that you've rejected all previous plea offers and that you decided to proceed with trial. This is a very, very complicated process, more so for us than it is for you. There's a big difference between a trial file, both electronically and a hard copy, and a file that doesn't go to trial. Your evidence needs to be organized meticulously so it is available at our fingertips, on our laptops, and in our hands at a moment's notice. It needs to be presented in a form so that we can put it in front of a jury in a way that they can understand it. We need to prepare for questions regarding every witness against you, and we need to prepare every single witness we're using on your behalf to make sure that person's testimony is as effective as it can possibly be. Any video or audio material that we want to present needs to be organized, disclosed to the state, and then a copy needs to be provided to the court before we engage in trial. We need to prepare questions we're going to have for the jury, if it's a jury trial. We need to prepare opening remarks. We need to prepare arguments for acquittal, and we need to prepare closing remarks as well. All of these things are things that we only do in anticipation of a trial. None of these things are necessary if the case is going to resolve through a dismissal, through a pretrial motion, or through some sort of plea agreement, which will involve a change of plea. All of this trial preparation constitutes probably more than 50% of all the work that needs to be done to try a case. For every hour that we're in trial, we probably spend 2 hours preparing for that hour. And we don't do it alone. We work very, very diligently to make sure every variable is accounted for and that the answer to every question we might ask during the course of that trial is a question we already know the answer to. So this is a very, very long and difficult process. And when we are in trial prep, usually we're not doing anything else. We're not focusing on any other clients. We're not taking any other phone calls. We're generally working nights and weekends to make sure that when you go to trial, you see the fruits of our labor and you realize that the best attorneys you could have hired are the ones that are trying your case. And we work hard to make sure that that happens. We also pride ourselves in the ability to try a case. We can't try a case well unless we're fully prepared. Most of that work is going to be done by us. Some of that work will be done by you, possibly not much. The only thing you need to do to prepare for trial is prepare your testimony. But oftentimes our clients don't testify at trial, in which case the only preparation you really need to do is mental, because you're going to have to sit through the trial with a poker face and not show that jury any emotion one way or the other, so that they don't use that as an indication of guilt. If you have questions during the course of the trial, you can write them down or whisper in our ear. And if you are testifying, certainly we'll go through your testimony either before or during trial. Remember, if you testify last. So we will have time after trial is concluded for the day to go over that testimony again. And of course, we'll try and make a preliminary determination during trial preparation as to whether or not that's something we want to do. But if there are witnesses, those witnesses will be contacted and they'll be told what is expected of them during their testimony at trial. Everything else is up to us. Remember, we've done this before, so don't get so nervous just because you haven't. If you have any other further questions, feel free and contact our office or utilize the frequently asked questions link that we've already provided. Thank you very much.
Stanley, we fight